Hello viewers, Namaskar. I am Professor Vageshwari Deswal, a professor at Faculty of Law, University of Delhi. We are doing a series on new criminal laws. In today's session, we will try to understand the changes in crimes relating to property. The two main changes that have been brought about in property offences are, first, the dimensions of the crime of theft have been enlarged in order to make it contemporary, and secondly, a new kind of crime has been introduced, and that is snatching. So today, we will try to understand these offences of theft and snatching as they have been defined under the Bharatiya Nyaya Sanhita 2023. Section 303 of the Bharatiya Nyaya Sanhita defines theft. So, subsection 1 of section 303 provides that whoever intending to take dishonestly any movable property out of the possession of any person without that person's consent moves that property in order to such taking is said to commit theft. So you see, primarily the definition appears to be the same, because what are the ingredients of theft? There has to be dishonest intention. Then theft can take place only in respect of movable property, and in committing theft the property has to be moved out of the possession of any person. See, theft is not necessarily an offence against ownership. Theft is essentially a crime against possession. So what is required is dishonest intention, the nature of property has to be movable property, there has to be taking of the property has to be taken out of the possession of any person, there should be a lack of consent, and the property should be moved in order to such taking. So that constitutes theft. So now how has this changed? The term movable property as it appears in the definition of theft has been defined under section 2 subsection 21 of the BNS. So this defines movable property to include property of every description except land and things attached to the earth or permanently fastened to anything which is attached to the earth. So you see, when we are talking about property of every description, now this is a definition which has to be understood to include all sorts of movable property, whether that is corporeal, incorporeal, tangible or intangible. And then there are certain properties that have been excluded, that such as land and things that are attached to the earth or permanently fastened to anything which is attached to the earth, because such property is not movable property, that is immovable property. So, the definition of movable property as it appears in the Bharatiya Nyaya Sanhita has been made broader than the definition that we had in the Indian Penal Code, because section 2 subsection 21 of the Bharatiya Nyaya Sanhita omits the words movable property are intended to include corporeal. Now these terms intended to include corporeal, which appeared before the word property in the definition of movable property in section 22 of IPC, gave it a very narrow and a restricted definition, in the sense that it could be only corporeal movable property that could be the subject matter of theft. And that is why we had to enact a separate Electricity Act to deal with instances of theft of electricity. Why? Because electricity is not corporeal, whereas under the old IPC, it could be only corporeal movable property that could be the subject matter of theft. So now, movable property includes property of every description other than immovable property. So now whether such property is incorporeal, it is in tangible form, it is in physical form or not. So the definition of movable property has now been widened considerably. Definition of movable property under Bharatiya Nyaya Sanhita will now include intangible assets like patents, copyrights, etc., also as well as actionable claims. So definition of theft will include instances of data theft also, and now this is going to cover online stealing of funds that happens by hacking of bank accounts. So in view of the expanded definition of movable property, now theft includes theft of intangible assets, theft of data, theft through card skimming, online theft that takes place through hacking of bank accounts or sometimes by cloning of mobiles and etc. Then when we refer to section 3, subsection 2 of the Bharatiya Nyaya Sanhita, it lays down a general explanation and it says that every expression which is explained in any part of this Sanhita is used in every part of this Sanhita in conformity with the explanation. So what it says is that any expression, see, no matter where that explanation it appears in any part of the Sanhita, wherever that term is used, so that term is to be specifically interpreted, understood and construed in conformity with the explanation that has been given under the explanation clause under section 3 itself. So now in view of section 3 subsection 2 of Bharatiya Nyaya Sanhita, the term theft in section 303 will also cover offences that are included in scope of theft in the inclusive definition of theft in explanation to section 112 subsection 1. In terms of that explanation, now theft will include trick theft, theft from vehicle, theft from dwelling houses, theft from any business premises, cargo theft, pickpocketing, theft through card skimming, shoplifting and also theft of automated teller machines. Now, punishment for theft has also been increased. Under section 303 subsection 2, which prescribes punishment for theft, the law says, whoever commits theft shall be punished with imprisonment of either description for a term which may extend to 3 years or with fine. So viewers, this part of the punishment is the same as was provided under the Indian Penal Code. But then further what does it say? In case of second or subsequent conviction of any person under this section, so here we are talking about repeat offenders, then the punishment that has been prescribed under the law is rigorous imprisonment for a term which shall not be less than 1 year, but which may extend to 5 years and also with fine. So you see that in cases of theft where the offender is a repeat offender, then we have prescribed minimum punishment. So now no matter what the reasons behind the commission of the crime be, if an offender is committing this crime of theft repeatedly, then he shall be subjected to a minimum rigorous imprisonment of 1 year, and then there is a discretion with the judge. If he wants, he can award a sentence up to 5 years also, and then it is to be also accompanied with fine. So you see, this is how punishment for theft has been increased. Now coming to the progressive part of the penology, which prescribes community service. Community service is a new kind of punishment which has been provided for the first time in our Bharatiya Nyaya Sanhita. And this is also prescribed only in a limited number of crimes, one of which is theft. So what does the law say? In cases of theft where the value of stolen property is less than 5,000 rupees and a person is convicted for the first time, then Upon return of the value of property or restoration of the stolen property, then the accused shall be punished with community service. So, viewers, you see, it is not every instance of theft which is punishable only with community service. Where community service is to be awarded, what are the conditions that make an accused eligible for award of the lesser punishment of community service? 1. The accused should be convicted for the crime of theft for the first time. So, if he is a repeat offender who was already convicted, then he is not eligible for community service. Second, in addition to being a first time convict, the value of the property that was stolen by the accused should not exceed 5,000 rupees. Then, the accused should be willing to return the value of the property, or he should be willing to restore the stolen property. Then it is only when these conditions are fulfilled that the courts can decide to award a lenient punishment to the accused person, and then instead of sentencing the accused to be put behind the bars, we can let off such person with the punishment of community service. Now, why has this provision been made? Because sometimes we have seen that people, they are driven by circumstances, maybe extreme poverty, to commit the crime of theft. Sometimes hunger drives them to commit a crime which they would not have done otherwise. If we go by the ordinary definition of theft as given under the IPC, then such a person is also to be punished. But taking care of this background, of the circumstances in which such a person was compelled to commit a crime, if such a person is a first time offender, the value of property is less than 5,000 rupees, he is willing to give back the property, or he is willing to return the value of the stolen property, then in such cases we can take a positive approach, we can take a lenient approach, and we can punish the accused with community service instead of sentencing the person to imprisonment behind the bars. Then, we have also introduced the concept of petty organized crime in BNS for the first time. So, when we talk about petty organized crime that takes place in respect of property, so there is a confusion whether the accused is to be convicted under provisions regarding theft or whether the accused is to be punished for petty organized crime. So, viewers, it is very simple. If the offender commits the theft alone, that is when he is operating by himself, when he is doing it solo, and when he is not part of any gang or group, then it is something which is punishable under this section as the crime of theft. But in cases where the offender commits theft as a member of a gang or group, then the offence becomes punishable under section 112 of the BNS as petty organized crime. Then let us talk about the crime of snatching. Section 304 of the Bharatiya Nyaya Sanhita introduces a new offence that is titled snatching. Now, snatching was a crime in some states such as Haryana, but we did not have snatching as a crime under the central law, which was the IPC. So, you see, it was up to certain states whether they wanted to make snatching a specific crime or whether we usually proceeded with theft, then directly to extortion, or then coming to robbery. So, now snatching is something which falls between the crime of theft and robbery. Snatching, in common parlance, it means to take something with a quick rough movement. When you snatch something, it suggests something which is more sudden, which is more quick. When you snatch something, you grab it. It could be by usage of force. So, snatching is a crime which usually occurs against women and the elderly people. We often hear cases of chain snatchings, mobile snatchings. Sometimes it can also result in physical injury to a person. See, when the accused snatches a chain, snatches a mobile or your purse out of your hands, the person might suffer a jerk and might fall, which can lead to further physical injuries. Then suppose somebody tries to snatch a chain, pull at your earrings. So there might be a cut that the victim suffers due to the snatching of such chain or earrings. There might be a cut on the neck, there might be a cut on the ears. Sometimes ear lobes get torn. Then when we talk about mobile snatchings, which is very commonly happening nowadays, mobiles, they contain lot of sensitive information. They contain data. We've got smartphones nowadays. All our passwords, financial records, bank information, it is all there within our mobiles. So this was the reason why we needed to introduce such a provision and the specific offence of snatching to deal with such crimes. So section 304 of the Bharatiya Nyaya Sanhita defines snatching. It says, theft is snatching if, in order to commit theft, the offender suddenly or quickly or forcibly seizes or secures or grabs or takes away from any person or from his possession any movable property. So, in order to constitute snatching, the first requirement is the ingredients of theft must be there. So, what this implies is snatching can take place only in respect of movable property. There should be absence of consent and it must be taken out of the possession. So, what is required in order to constitute snatching? First, there must be the ingredients of theft, and then it should be accompanied with a sudden or quick or forcible seizure or securing or grabbing or taking away from any person or from his possession any movable property. Now, what is the punishment for snatching? That is provided under section 304 subsection 2. It says, whoever commits snatching shall be punished with imprisonment of either description for a term which may extend to 3 years, and it shall also be liable to fine. So, you see, to constitute snatching, there must be all elements of theft, there has to be dishonest intention, there has to be absence of consent, and there has to be movement of movable property. Now again, this confusion whether an offender who commits snatching is to be punished under section 304 or under section 112 for a petty organized crime. So again, the simple answer, if an offender commits snatching alone by himself, when he is not a part of any gang or group, then it is punishable under section 304. But where the offender committing snatching, whether it is chain snatching, whether it is mobile snatching, whether it is anything else, when such an offender is a member of a gang or group, then the offence of snatching gets punishable under section 112 as petty organized crime. See, so many times we have seen there is one person who is driving the motorcycle, the other one is the pillion rider, and he is the one who does this offence of snatching. Then there are cases, there is one person who does the snatching and he hands it over to some other person. So when it is being carried out in an organized manner, then it is covered under section 112, otherwise it is covered under section 304 of the BNS. Now, why did we need this provision in the first place? The benefits of having a separate provision regarding snatching is first, victim protection. See, when we create a specific offence for snatching, we acknowledge that this is a crime which has a great impact on victims. Many times victims suffer physical trauma, many times they suffer emotional trauma, and in addition to that, they have also suffered loss of property. So, first is we need to protect our victims, then we also need to protect our valuable data that is present in our mobile phones, our smartphones, which contain lots of sensitive information, personal information, financial data, we have our passwords. Now all these are protected by separately making the act of snatching as an offence. And when we have made it a separate offence, when we have prescribed punishment for that, so this also acts as a deterrent. So this has the capacity to discourage potential offenders from resorting to snatching. It sends out a strong message that see, the government, the state is very serious to tackle this crime, and if you commit snatching, you would be punished. So now we've talked about what constitutes theft, what constitutes snatching. Now let us try and understand how theft and snatching are different from each other. See, theft is a much wider term than snatching. Theft covers theft of all kinds of movable property, whether it is corporeal, whether it is non-corporeal. Theft would also cover theft of intangible assets as also theft of data, theft of identity. But in theft, how is it different from snatching? Because in theft, usage of force is not necessary. Snatching involves theft. However, every theft does not amount to snatching. A theft would amount to snatching only when it satisfies the definition of theft under section 303 subsection 1 and when the offender suddenly or quickly or forcibly seizes, secures or grabs or takes away from any person or from his possession any movable property. See, theft can be of tangible movable property as well as data and intangible assets. While when we talk about snatching, snatching can only be in respect of corporeal movable property. See, intangible movable property such as data and all, that cannot be the subject of snatching. The object of snatching can be a mobile phone. Data that is contained in that mobile phone, it cannot be snatched separately or apart from the mobile phone. So you see, theft can be of tangible as well as intangible movable property, but when we talk about snatching, a person can be booked of snatching for only corporeal movable property or tangible movable property. Then, when we talk about punishment for theft and punishment for snatching, there is a difference. In cases of first-time offender, in cases where value of property is less than 5,000 rupees, the accused may be punished with community service. But in cases of snatching, we have not made provision for any such leniency. Because see, snatching is not only an offence against property, it somehow directly or indirectly it also interacts with the segment of crimes against human body. When you are snatching a property from some person, there is also usage of a criminal force against the other person. So there is no leniency that is shown in cases of snatching. Then when we talk about the nature of the crime, theft is compoundable by owner of stolen property. Snatching, it is non-compoundable. So snatching is more of a hardcore kind of a crime. Even if the victim wants to condone the accused person, the state doesn't allow it to be done because snatching is something which cannot be permitted in any state. So snatching has been made more serious and it is non-compoundable in nature. Then there is a new provision in the form of section 305 which has replaced the old section 380 of the Indian Penal Code, and additionally many new points have been added therein. See, section 380 had a very restricted and a narrow definition. Now what 305 says? It deals with theft in a dwelling house or means of transportation or place of worship. So as per the new provision section 305, whoever commits theft in any building, tent or vessel that is used as a human dwelling or which is used for custody of property, or whoever commits theft of any means of transport used for the transport of goods or passengers. So you see instances of car theft, vehicle theft. Now all that is being directly covered under this provision. So it also includes whoever commits theft of any article or goods from any means of transport used for transport of goods or passengers, or whoever commits theft of idol or icon in any place of worship or of any property of the government or of a local authority, then the punishment that has been prescribed is imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. So, in all such cases, the quantum of imprisonment, it has been raised. Now, the punishment, it can go up to 7 years. So, you see, vehicle thefts, now they come under section 305B of the Bharatiya Nyaya Sanhita. Earlier, it would be covered under the broader category of theft in the IPC, which was dealt with under the old section 379, which had a punishment of 3 years. Now, under the new law, the police have to visit the spot immediately on receiving complaints. They are required to film the crime scene. It is all mandated now under the law. The cases are registered as an EFIR in the crime branch. The SHO has to assign investigating officers at the police station level. The police team is required to videograph the entire procedure of checking the vehicle and the driver. See, we have SOPs regarding all this, and this ensures that the accused the accused is not able to claim that evidence was planted or tampered with. Now, videography is mandatory, not only for the spot, but also during search of the suspect and seizure of the vehicle. Then, when we talk about how offences of petty theft are to be tried, now summary trials have been mandated. The monetary limits for petty theft that are triable in summary trials in terms of value of stolen property involved has now been increased from 2000, which was under section 260 subsection 1 of CRPC, to rupees 20,000 under section 283 subsection 1 of the Bharatiya Nagarik Suraksha Sanhita. Section 283 of BNSS, it makes summary trials mandatory for petty and less serious cases under CRPC. It was discretionary for the magistrate to try petty and less serious offences in a summary way, as section 260 subsection 1 of the CRPC use the words may, if he thinks fit, try in a summary way all or any of the following offences. Now, section 283 subsection 1 of BNSS replaces the word may with that word shall, and we have also increased monetary limits for petty offences to be tried summarily. So, viewers, in this session we tried to understand how the crime of theft, it has undergone a change, and how we have introduced new dimensions to the crime of theft, and at the same time introduced the new crime of snatching. Hope you enjoyed this session. Thank you.